We have said that we do not find any illegality in the action of the statutory authority in raising a demand of a differential amount. We thus dismiss. However, we extend the time for payment. We have said that we do not find any illegality in the action of the statutory authority in raising a demand. What is this?
No, my lord. This was on by what I am actually.
Oh.
May pardon. Page 6 of the weekly list, item 33. I have given the memo. Urgency is there.
Let us move. Let us move.
To the last matter.
Yes. We'll try to move fast.
That is in the weekly list.
Oh, sure. These are only two matters are there in the supplementary.
Orders item number 2.
Yes. What order? What is the matter?
Regarding extension of the time for vacating the premises.
Oh,
BRT order was confirmed by this honorable court. Review was dismissed, then they went up in SLP. SLP was dismissed. However, a liberty was granted to them that they can re-approach the High Court if they want some time to vacate the premises. So, and in that, but in the application,
you were saying that something is happening on 25th, I think.
Yesterday was the last day.
What has happened? Taken out or thrown out or?
No.
Yes. Who is for the state?
The bank.
Is a bank?
The bank.
Here is a direction was made to the police.
But it is a review application. Why? In the review, why?
They have filed in the review.
What for review?
For extension.
Extinction and review.
More time we need. Because liberty was granted by honorable Supreme Court.
Where is the liberty? Which page?
And this is page 10 of the IA.
Where is the IA?
That is what I IA number 391 of 2026, which they have filed in the review.
Is that liberty?
They have filed a IA in review. So you do not want to proceed with the review if the time is extended.
No, the liberty is only to the extent of time extension. The SLP has been dismissed.
Where is the order of the Supreme Court granting of liberty?
Page 10 and paragraph 3.
Oh yes, this the page 10.
Yes.
Is there. Passed by the High Court, the petitioner is liberty to approach the High Court for seeking extension of time for vacating the place.
The auction was in 2017 or 18.
What to do, sir? How much time you have sought for?
6 weeks.
6
months.
6 months.
Like my father is suffering from cancer. I have also
It's a
annual
commercial building.
Completely commercial.
It's a commercial building. Then what is the use?
And you'll also just have a glance at paragraph 9, the application of the IA that they have filed. 9 and 10. And to take such lawful steps as may be available in accordance with law. So it's a condition. That is attached with a condition. And no, I'm not. I'm just saying, may not be.
Is the wisdom of a draftsman.
Commercial place including 2 ATM counters of different banks.
How much time?
I leave it.
No.
Lord, we have made the entire deposit.
I know.
It's long,
I know.
so the
I know.
entire amount was deposited.
But I am encouraging a lost pattern.
No. It's nothing.
Only some time you're Lakshmi Rakni, that's it.
I'm asking them how much time.
The cancer patient,
Your
Oh,
lordship.
it's a commercial property, sir, they have said.
My lord,
So,
what my
It's
learned,
not a residential property.
my lord, what my learned friend says, since the upper two floors, I think I don't know if they're staying or not, but that is not yet lit out.
Don't go partially.
No, my lord, what I'm saying is the commercial area should be locked down first. Because that is what is giving them the privilege for which they want this. Otherwise, again, they will rake up through a commercial property owner or something. They will try to again make it be.
those restrictions will be there, will not do anything, just some time will be granted, not end of the matter. Therefore, their approval will not also come to your office.
4 weeks. 4 weeks, what?
No, so why this apprehension? Because para 10 of your.
Yes, 9 and 10.
I have read the words, I have read the language, the lordships have used it, I have read it. I have raised my hands, my lord. Therefore, I say it's a mercy application, that's all. As my learned friend says, I can dispute it also, I don't know.
The
at the bank level.
For very good reason, it should be recorded.
Uttered a single word.
When number two has.
No, yes, that's why. Yes.
This is a person.
Yes, now the Advocate General is here.
Yes.
You appoint the Vice Chancellor in the Odisha University.
Yes, I was just already appointed. Already appointed,
Already appointed, then what will
4 months back. In April.
Let's see. This read, this,
you have come.
no, I filed prior to that.
Maybe now.
January.
Now they have already appointed, then what remain?
Only I pray that the rule of law should be enforced.
What rule of law unnecessarily what you
The
are doing?
Lordship may see,
Indirectly, then we will be entering into the.
no, I don't
modus
want,
operandi of the.
I don't want that, my lords.
But what is this notification annexure one?
Yes, annexure 1. Lordship page 23.
Huh.
Here, they have constituted selection committee.
Selection committee.
This
Of these members.
yes,
And they have already selected a person and the Vice Chancellor is appointed.
that is what I was challenged. It was challenged because this came in 13/1/2026 and I filed it in on same January 2026.
Sir, why you are so much against those
I'm not on
the
that.
constituent of the selection committee?
I'm not that. Lordship may see why. Why?
Why?
Lordship may see the act. Can I take it to the act page 38?
What do you want to say in the
Yes, just I'll
has
read
it
it.
said that who will be the constituent of the selection committee?
I'll just read out.
Please.
That's page 38 of my brief.
What is this?
Section 8(1). The Vice Chancellor shall be a whole-time direct officer of the university and shall be appointed by the Chancellor from a panel of 3 names, recommended by a committee consisting of 7 persons, of whom 1, next page, shall be nominated by the Chancellor, 1 by the board, 1 by the University Grants Commission, and remaining 4 members shall be nominated by the government. Now, if you actually take it to that impugned annexure, here, these 4 members which have been nominated by the state are all in contrary to this statute.
Why?
Because why? Here, this is a special university, Odia University Act. Now, this act came into force in 2017, my lord. And here, all these persons are from Sanskrit University.
So it does not say, it simply say that
Yes.
it's the freedom of the government to
Yes.
nominate any person.
The Lords may
Now they
see.
can nominate any person. Does not mean that it should belong to the same university.
That is Lords may already
You can't.
Yes, that is
define that,
what
no?
Why I'm saying, they have a Sanskrit university. They have, but here, the persons who have been selected are not professors. Neither they have 10 years of experience. That is what page 29 Lords of see, and it's a free advertisement.
No, what the act says.
Act says same thing.
Who could be the Vice Chancellor?
Yes, it should
What
be
is the
have.
eligibility
Yes,
criteria
that
for
is
the
what.
Vice Chancellor?
Yes, that is what.
Show us.
That is what. The Lords may see 8(1).
Yes.
And 8(1) I've read. Lords may see.
Where is the eligibility criteria for
appointed as the
that for Vice Chancellor? That
Yes.
he should have 15-year experience of the Vice Chancellor. All these things. Where are the eligibility
The
criteria?
criteria is page 23.
Challenging the constitution of the
I
committee.
understand.
Yes, that.
He is
I-
going into the other aspect.
Others.
No, I'm not going into the other aspect.
Yes.
Let me see that this advertisement is at page 29. Lordship, see, page 29. Can I read it out? Yes. For the position of Vice Chancellor Odisha University, Satyavrat Puri, the applicant should be a distinguished academician of proven academic. Can I interpret that it should be in Odisha?
Who are you, sir?
No, I'm not saying.
So,
Just my interpretation. And
Proven academic and
Yes.
administrative excellence. It
excellent.
all depends upon a person to a person. If somebody has been chosen as an academic,
Yes,
having a vast experience or gained a lot
I
of
agree, ma'am.
It
And
should be,
again,
the only thing is well-rounded personality
Yes.
with a minimum of 10 years experience as professor. That's
Professor.
all.
10 years of experience as a professor.
That's all.
Here, I don't think so.
From
Now-
now you get it that he has no 10 years experience, select committee.
That
It is
that's
also not the challenge, not only two players, we are challenged to not page.
No, he
18,
wanted
no.
this notification of
Yes.
his constitution.
Yes,
of the
that's
selection
correct.
committee.
Yes.
and also the nominee of the chancellor, who has been appointed as chairman. There also again,
Uh,
he is a person against whom he has faced some disciplinary action in 2006, and he is a reader, and he is not a professor.
The problem.
He is not a professor.
Sorry, we can't.
Lordship, see,
We can't.
he is not a professor. He is a reader. I have filed that document. And you'll also see the suggestive guidelines.
There is nothing, so far as the qualification of the selection committee is concerned.
Yes, that as per
There
Lordship,
is nothing which says that selection fee.
page 25.
Selection committee
Yes,
must have this qualification. It simply talks about, you have taken to section 8(1). It
yes,
simply talks about the nominee of the government. It talks about the nominee of the chancellor. That's
Madam.
all. And if the chancellor has chosen anyone as a chairman, then what?
But I don't, my lord, I don't.
Then why
only
was
question is-
going for a selection
Only question is that rationality that these persons have been elected in accordance with law or not.
Sorry,
In
the
the statute.
selection, you are challenging the selection committee.
Constitutional
That's not
selection
a real-
committee?
We have to be,
Yes.
to be so informed. Now, if they have chosen a particular person,
Yes,
the qualification is already given, that he must be an academician, he must have he has excelled in the profession 10 years
10 years of
as
experience.
profession. Now, vice chancellor who has chosen,
Vice chancellor was chosen, well,
is a
pendency.
professor,
He's again, right, it's a professor of a Sanskrit university.
what may be,
That
maybe, sir.
only to that end.
So, the vice chancellor post is more administrative. Yes.
Section 16 of the Act, which says the academic councils are the apex academic body of the university and subject, that is page 48. So why the vice chancellor should be from the professor and of Odisha University?
Where?
And what I'm just pointing out is,
Sir, why there should be a vice chancellor from the same university?
Yes, that's-
why.
that is what I'm coming at page annex,
Actually,
that is
which
section
one you say,
16.
the academic council.
Yes.
That's a different council.
Yes, but why?
The apex academic body of the university and its statutes
Yes.
shall coordinate and exercise general supervision of the academic programs.
Yes,
This is the relation to a different
Right.
functions.
right, my lord. But the Lordship says shall be responsible for maintenance of standards of instruction,
That is the academic council.
research, education. Now, two, the academic councils are considered following, namely, ex officio member is the vice chancellor.
Why not?
That is
It's a
what I'm saying.
body. Sir, it's a body.
Yes, that is what I'm
So-
saying. Either he should be having
His
academic.
decision alone is not paramount. It's a whole
Only
body.
Yes, I understand.
Consequent to it.
that I am aware of. Only question is that why at least 50 professors are there, Odia professors are there.
Yeah. So they should be made a vice chancellor.
Not that. Having 10 years of experience.
So it is all the select committee, sir. Why the select committee? If the select committee will choose, somebody may have a 10 years experience, not good enough.
My lord.
What? What?
That mean, but question is that qualified persons are there.
There are qualified. Why you want? There are many qualified persons. Then you are opening a very big Pandora box in all other sectors.
Only to that part. Nothing else, man.
No, sir. Don't control the affairs.
No, I'm not saying that.
Don't overpower it. If you, what you are saying is that if there is already professors in the Korea University, the vice chancellor must be chosen among them. I think this is absolutely wrong. Absolutely wrong.
I'm not saying that they should be, but
No, sir. Why
Parity.
should why it should be?
parity.
No parity. Then
Because
I mean that I'm speaking to my own conscience and a decision which I have taken very recently.
on the same issue,
What are you arguing this?
I've not gone through that way.
I'm speaking to my own conscience.
Only preference could have been given. That's all.
If the statute does not provide any preference to be given, I think when you are aware of various rules, yes, it says that a preference will be given to a local person who is a resident of the locality. That means that if they comes at par,
Yes.
then the preference would be there. Suppose if there are three persons who have secured the equal marks or found to be an equally qualified, then amongst three, the one who is a local, then in that sense, he should be given a preference. But not when he is not meritorious, he does not come in within the any bracket. It is only on a situation when there is an equality.
That's right. That's right.
What you mean probably is that the person should have been selected whose very medium of speaking is Korea.
No,
Not that.
That's not.
Not that. Not that.
University, there are many professors.
Professors were meritorious.
Why they are not chosen?
That is only preference.
You are saying preference must be given to
Must.
a eminent person, professor, and
Yes.
expert knowledge of Korea. Its medium of teaching and research. How can it be?
But that is what I was interpreting.
You were in the impression that
I
probably it is that.
believe, if I am not wrong, I think the every language
That's right.
originates from a Sanskrit.
There are these there.
I think every language.
I do agree. About it. Not my permit to withdraw it.
No. No.
Oh, this one.
Without going, without delving deep into the maintenance. give that reference of the one.
Master Mallikarjun versus Divisional Manager National Insurance Cooperative Limited, that is 2014, volume 14, SCC 396.
Yes.
Item number 2.
We will read it. Paragraph.
Who other judgments also before
So
that?
subsequently, Mallikarjun is the first.
That
I always remember the foundational judgment. And it is followed subsequently. Yes, what is this, sir?
No, this is with regard to the
Just 1 minute.
Chief Minister and Deputy Chief Minister. When the Constitution
I have to learn. But please, I must feel very content that I am ignorant and have no knowledge. Please enlighten me because I should not remain ignorant throughout my life.
although it is earlier in the case pillar, here the case is the appointment of the board proceedings for the Deputy Chief Minister. Two Deputy Chief Ministers are being there in assembly. So there is the Constitution does not provide such post at all.
Okay.
As a Minister or Chief Minister.
Then
But
what?
where is the Deputy Chief?
I do not.
And here I oppose that is maybe a descriptive, ornamental word may be there, but the perks and privilege, the protocol system is not being followed. That is why we are opposed to
You wanted
this
them to be
designation.
given a more perks and more privileges. Yes, we can direct the state and through Advocate General revise. It should be a part. Give more perks to them, more facilities to them.
Then more about the post of Deputy Chief Minister is not available under the
That
Constitution.
is what I really wanted to know, that where is a bar, where is an absolute bar that it cannot be done. That's why I say, see, they enlightened me on the proposition of
Then
law. I am not aware of this.
164 of the Constitution.
Constitution give it. No constitution of it. One,
Well, 162. Then I'll start from 163 million.
63.
Council of Ministers to aid and advise the governor. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of these functions, except in so far as he is by or under the constitution required to exercise his functions or any of them
Yes.
in his discretion.
Correct.
If any question arises whether any matter is or is not a matter as respect which the governor is by or under the constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the grounds that he ought or ought not to have acted in his discretion. The question whether any, and if so, what advice was tendered by the ministers to the governor shall not be inquired into by any court. Then 64. The chief minister shall be appointed by the governor and the other ministers shall be appointed by the governor on the advice of the chief minister and the ministers shall hold office during the pleasure of the governor, provided that in the states. So the question is, there is no deputy chief minister.
No, there is very easily another the portfolio of the ministers. only one post is there,
Chief Minister.
the chief minister.
The others are
Says
ministers.
that the council of the ministers, it does not say that what should be the designation of the council of the ministers. Now, if the designation is not given, then it can be given in any name. Is he not a part of the council of ministers? I'm asking. If he is a part of the council of ministers,
Council of
then this article 163 does not say that what nomenclature should be given to each minister. Then in that event, it is a
But it has not given any such nomenclature other
Nothing
than
for
saying
any-
minister.
Not even a law minister, not even a finance minister, nothing is given.
So it is the department. Law minister.
No,
means
what are you
department.
talking about? Department.
Minister-
The Council of Ministers is a department, never.
Like Minister of Law, Minister of Agriculture, Minister of Science
It's
and
not a
Technology.
department, sir.
But no deputy chief minister.
I
is
am
there.
asking, sir, I am saying is that Council of Ministers does not indicate that there should be a finance minister, there should be please consider that.
Right.
It does not say that there should be a finance minister designation, a home minister designation, the transport minister designation. No, it simply talks about the Council of Ministers.
Ministers.
Now, Council of Ministers may have varied designation. It may be not heading a particular department, but overall the control and the administration. It can be done.
Then chief minister. Chief is
There is a-
qualifying what is there? Chief.
There-
Chief.
That is
Minister.
That means the chief minister is the constitutionally recognized.
By the
But
deputy chief minister is not recognized there.
this is
Deputy chief minister, then deputy chief minister.
probably I am not very able to convey myself. The Council of Ministers, if it is there under Article 163, means whoever is given a ministry or a portfolio as a minister, they will constitute as a homogeneous class of Council of Ministers. Now, it is for an administrative convenience, I believe there must be a rule of business or something.
Correct.
It is there which permits certain nomenclature or a designation. It is up to the chief minister to assign any particular work to any of the ministers, either independently or along with somebody else.
That is with regard to ministers.
Sir,
Minister, the nomenclature
Chief Minister
minister.
does not come under the Council of Ministers. I am simply putting a question. Whether he is not coming within this bracket of Council of Ministers.
Should be. Should be.
So is there?
But not there. It is deputy chief minister.
He's
That
a,
is-
he's
that-
a
that
one
is
of the
the-
part of the Council of Ministers.
That's a
Mr. Mahant, probably you have not gone through this similar PIL has already been set at rest by Supreme Court in 2021. On this subject itself,
Where is that?
Justice Chandra Chudhan.
I'll cite one by one. A dozen judgment sites, sir.
Well,
I'm waiting for my.
the first is in the case of Debilal issue that I'm
No, in
asking.
fact, 21 it has only on the point of deputy chief minister by different states.
Same.
It is there not to
Show me
give
that
it.
judgment. I believe if you have in your form.
Yes, but I should
Please
because
give
I
it.
do
I
not
think that
want
is,
to
that
disturb.
covers the
Wait.
entire scenario.
But with
Exactly.
cost, Miller, with a heavy cost.
Yeah.
Let me see.
We coordinate
Please
benches of
show me the
High Court.
judgment. I
That is
at the
similar.
very outset, I just.
Miller, one by one, I'm
The
finding.
senior counsel that.
Let's
Please enlighten me on
Let it
this.
over. If your lordship would permit,
Please do it.
should I?
That's
Should I go to the constitutional provision or straightway to judgment of
that's the only point. He
That's
is raising a
right.
point
Can
that
we
there
take
is
off-
no recognition
One-
of deputy
this-
chief minister post under.
That's
the
correct. That's
Constitution.
very
I
silly.
think that's a very simple.
Crux and coming without hitting at the crux. Lordship may turn to the first Om Prakash Solanki, Rajasthan High Court.
Yes.
The Chief Justice, Acting Chief, and the all divisional bench. It is a recent judgment which has taken note of all earlier judgments of different Karnataka High Court and Bombay High Court, and also K.M. Sharma, Supreme Court, Devila, Deputy Prime Minister. I am citing. And incidentally, Mira, the petitioner in this Rajasthan case was a lawyer, like the present one. saddled with a cost of 25,000. Your Lordship, I am reading. Filing of frivolous petition, the opening paragraph.
No.
Has-
First being,
No, I'm just, Your Lordship.
no, I think paragraph 5 is the,
Yes,
first we have to
answer.
find out what is the issue.
Issue same
Paragraph
issue.
5 is correct.
Milord, your Lordship, kindly let me read it. It's a very interesting judgment. I have read it for myself also. Your Lordship, this is an interesting issue also. It should be addressed. Filing of frivolous petition has been on assent to gain cheap publicity.
which paragraph?
Para 1. Para 1.
Achha.
Your Lordship, let me,
Yes.
let
Yes,
your
sir.
Lordship hear
Yes.
this. It's an interesting issue. Let it be set at rest. Frivolous petitions in the name of public interest are being filed without proper search and without proper examination of law and legal position. Present case is a classic example of a frivolous petition. This is the opening word Justice Srivastava subsequently. So the petitioner, who is an advocate, without instant case also the petitioner, I suppose, is an advocate because he has described advocate of this court. Advocate has filed this petition seeking following reliefs. It is therefore most respectfully prayed that this honorable court may graciously be pleased to call for the entire record of the case. Same prayer, Milord, I will turn to the prayer. And be further pleased to declare the appointment of Diya Kumari.
Whatever, no, don't.
Yes,
Use the
the
name.
names, yes. As Deputy Chief Ministers of State of Rajasthan, as the post of Deputy Chief Minister is unconstitutional and invalid.
Same.
Milord, Your Excellency. Any other orders one should. In the body of the petition, the substance of pleading is that since there is no office of Deputy Chief Minister described in the Constitution, exactly the same issue Your Lordship was posing to the other side. The oath taken by the respondent number 5, this is also pleaded and says, as Deputy Chief Minister is wholly unconstitutional. During the course of argument, petitioner in person referring to additional documents filed subsequently would argue that on 30/12/2023, Cabinet Minister and State Minister independent charge were reported having taken oath which does not contain the name of the respondent number 5 and 6. Therefore, it is argued it has to be interfered that they had not taken oath. Well, here they have taken oath. So it is also submitted that under another notice dated 5/1/24, the division of business was notified. Query
Give him a
again-
copy.
Well,
I should have.
Well, it is a big order. I am giving all copies. Which one?
Reading paragraph
Rajasthan Para 4.
4.
Para 4. It is also submitted that the under so and so. It is the submission of that Constitution does not recognize any office as the Deputy Chief Minister, and therefore taking an oath as Deputy Chief Minister is unconstitutionally impermissible. And for that reason, respondent number 5 and 6 are illegally usurps the office of the minister. They can neither be allotted any work nor any other facility can be provided to them. Same argument, one by one. Mr. Rastogi, so and so, on advance copy appeared before this court on behalf of respondent number 3 and assisted this court by placing certain decisions for consideration to submit that the petitioner is raising an issue which is no longer res integra and stands settled in catena of judgments. The basis of the relief sought in the writ petition is that there is no office declared as the Deputy Chief Minister. The oath taken by respondent 5 and 6 as Deputy Chief Minister is unconstitutional. From the readings of the petition, we would not find that there is any specific statement of fact made, much less with any responsibility or the source of information that respondent number 5 and 6 have not taken oath. During the course of argument, we repeatedly asked the petitioner in person whether he has made any such averment, but here, Milord, they have taken oath. The fact is little. During the course of argument, it was also stated that the Constitution requires oath to be taken in Form 5, Schedule H1, appended to the Constitution. That the third schedule entirely deals with the oath. we then inquired from the petitioner whether it is his case. Respondent 5 and 6 have not taken oath in the prescribed pro forma. That is MK Samaj ratio. I'll come to that. As prescribed in Schedule H1 of the Constitution. On this aspect, there is neither any pleading nor any satisfactory answer. Rather, he avers that they have taken oath. It's a positive affirmation. All that has been argued before us, appointment of being unconstitutional, etc., must be taken as engulfing all affirmments like had not taken any oath. We are of the view, pleadings made in this petition are blissfully vague and mere and there is no specific affirmment in the petition. Respondent 5 and 6 had not taken any oath, much less any affirmation that they had not taken oath has the requirement of schedule so and so appended to the Constitution of India. In the case of Para 12, Sharma, Devilal judgment pillar, he is relying that his pillar rather pillar, he said it supports the state's case. I'll come to that. 1990 so and so, the appointment of respondent as Deputy Prime Minister of India was assailed on the ground that the oath administered to him as such was not in accordance with the prescription of the Constitution. But here, they relied upon that Rajasthan election case said that 173, the substance is material. I'll come to that. I was here, Deputy of India was assailed on the ground that the oath administered to him as such was not in accordance with the prescription of the Constitution. This submission made by the Attorney General before the court was like below. Learned so and so Attorney General appearing on behalf of the Union of India has stated that the firm prescribed in the third schedule pursuant to the requirement of Article 75(4) of the Constitution is only for a minister of the Union and there is no separate firm even for the Prime Minister. Like same thing also mirrored in Article 164(3). I'll come to that. So you're not even for the Chief Minister. Unlike you or sits oath as Chief Justice and Judge of High Court, and so it is specifically mentioned. If there is also no separate firm, I'll show to the third schedule. I'll come to that little later. So, but the Prime Minister, since the Prime Minister is also a member of the Council of Ministers, your Lordship was exactly proposing the same thing under the rules of business, Article 162. I'll come to that. So he maintains that in view of the fact that the Constitution describes him as the Prime Minister, while being sworn into office, he describes himself as Prime Minister, and this practice is in vogue ever since 1950. They came, someone they have quoted here. The oath registered is by the incumbent signed as Prime Minister, and all other ministers sign as ministers. He further indicates that describing Sri Devilal as Deputy Prime Minister is descriptive only, and for all purposes, he is a minister, and there is no constitutional sanction for the post of Deputy Prime Minister as such. But I'm going below. So and so, Learned Attorney General further contains that the prescribed oath should be divided into two parts. One which is descriptive and other which contains the substantial part. And according to him, as long as the substantial part is properly followed, a mere mistake or error in the descriptive, in all those election cases, it will also put that is the oath, whether he has taken oath or not, etc. Article 173, that is a ground of challenge for dismissal. So this Sutaria case is an election petition, incidentally, where the question of interpretation of oath came, whether there has been a substantial compliance or not. Thereafter, the Honorable Supreme Court proceeded to hold below. This court in the reported decision said, in this case, as we have already noted, the essential requirement of Article 173, read with Form 7A, was that the person taking the oath or making the affirmation would bear true faith and allegiance to the Constitution and uphold the sovereignty and integrity of India. This was also inserted by way of an amendment, if you remember, in the 15th Constitution Amendment, this concept of integrity when was introduced. That has also been discussed in the other decisions. The words which precede this portion are merely descriptive of the person of his nomination as a candidate. In view of the clear statement made by the London Attorney General, is a so and so minister, other members of the Council of Ministers, though he has been described as Deputy Prime Minister, description of him as Deputy does not confer on him any powers of the Prime Minister, along with his other submissions, we think past contention raised by the petitioner has no force. That was similar in paragraph 1, K.M. Lal, they have said to strike down the appointment of Devilal as Prime Minister by issuance of a writ of querent. So in the case of Devidas, it's a Bombay case. Devidas was also a professor. Karnataka was Professor Justice Dikshit is incidentally is a party to that. And Karnataka, they are here, Millard, your lordship may kindly come to the last. A cost, Millard, they were proposing to impose heavy cost. What is it? 25. No, here it is 25. In Karnataka, it is 10. You know, I'll give that. It is same thing. But 10, I'm coming to that. Filing EILs without proper search and raising an issue to challenge the appointment of respondent. Millard, I am reading this Rajasthan last.
No, I have already
On the
read the
basis of
I got
ease
it.
of decision
I'm coming
and
to that.
second can only be termed as a frivolous. Therefore, it is necessary to impose an appropriate cost, taking into consideration the entirety of the matter and frivolity of the petition. We are inclined to impose cost of 25,000 payable by the petitioner to the Rajasthan High Court Legal Services. One such order is, Millard, you are at least solicited from your lordship. Because, Millard, the state is also in necessity of some legal services, and he is capable of my learned senior, Mr. Srinivas. But he is a very rich person to contribute. Millard, Karnataka judgment, your lordship may kindly see now. Justice,
Well, before that,
Karnataka, I am reading, please, sir. I didn't, Millard,
No, I
Karnataka.
just want
He
to.
is going beyond the lines,
Justice Dikshit.
No,
beyond the lines.
it will be giving a better opportunity to you to.
To reply. Karnataka, you will have to come. Same thing. Karnataka, you will have to make kind of.
Judgment will go to copy.
You are, so Karnataka is a Karnataka. Yes, also.
Yes.
Devin, sir, qualified to me.
So Devidas was also considered there.
Yes, here also, Millard. Even Devilal was also, Millard, this submit, Millard, here, Millard, you will have to para 2. Petitioner is a professor. Here, Millard, there he was an advocate. Here in Bombay case was a professor. Here is a professor of law in Karnataka. Chief Justice Maheshwari and Justice Dikshit judgment. Retirement serving as director of Vivekananda College, Dakshina Kannada district, files also. That the designation of the fourth respondent
Yes, it's the same issue.
the same issue.
Same issue.
All judgments I am showing on only Deputy Chief Minister issue. Petitioner appointment of any person only creates confusion in the public, also in the bureaucracy. That is subserving the political causes of person concerned. Petitioner so and so, Governor of Karnataka appointed as Deputy Chief Minister of Karnataka, powers under Article 164(1). Then K.M. Sharma relied. Your Lordship may kindly. This has also been relied in Rajasthan case. Your Lordship, that paragraph I skipped. Your Lordship may kindly now come to Devidas Venkatra Paul, the Bombay case, Gopinath Munde case, Millard, I'm just passing on. That has been relied in para 6. There is no separate form. Millard, may I place para 6 of Bombay case? Bombay is same issue, Millard.
I think paragraph 9
Repetition.
of the Karnataka.
Kind of-
Paragraph 9 of the Karnataka.
Paragraph-
Very clear.
Yes. Clearly consistent decisions of the Honorable Supreme Court and also of different high courts, it is beyond the pale of doubt that mere description of any minister in the Council of Ministers as Deputy Chief Minister does not confer the person concerned with any powers of the Chief Minister, does not result in any unconstitutionality. That is very important. That being the position, we are further clearly of the view there has been absolutely no justification for filing this writ petition as PIL. Your Lordship may kindly then these PIL, etc.,
All the
etc.
judgments have been.
Yes, public, private, publicity oriented, etc., etc. Just B. Singh versus Union of India, Justice Pasai judgment, Millard, if your Lordship would permit, I would last part, your Lordship, para 11. The present one, para 11 is very important.
Of Bombay,
Bombay, I am just passing. Para 11 of Millard, Karnataka. The present one is an opposite example of entirely frivolous of Karnataka. I am reading here.
Yes.
That's a got it.
Yes, sir.
Sekharaya. Para 11.
Yes, yes.
Yes. Page 14. Present one is an opposite example of entirely frivolous, meaningless, unnecessary, and unwarranted PIL petition in this court, and that too by none other but a person who is engaged in teaching business law and is not oblivious of the legal process. Here the cost could be 5 times more. Advocate. 8 term. In view of the above, we consider it necessary to saddle the petitioner with heavy costs. However, the petitioner has pleaded before us that he had no ill intention but filing this petition, and he may be excused this time. And for that matter, he would undertake to render pro bono services. Let's see if I kindly mark this. Even by taking the words of petitioner as stated, we find it rather imperative that this petition be dismissed with costs. Of course, the amount of cost may be diverted towards some welfare measure. In the circumstances of case, despite having expressed serious paragraph 14, that you got the right paragraph, I was going to that. Accordingly, this petition is dismissed with cost, quantified as they became little lenient because the professor every day I do pro bono henceforth. So Karnataka, they became little lesser harsh, but should have been. That's up to your lordship wisdom and conscience. Then your lordship kindly. Now I am coming to Justice Chandrachud, my lord Justice Das. I am just coming. Your lordship kindly. One paragraph. Your lordship is correct. Public political party is also a two. I left one judgment of Bombay. Gopinath Mandir.
No, I was.
That's a but may I place that?
No, I have already looked.
Enough, please. Don't I think that has already. But Justice Chandrachud, my lord Justice Task Force, Lord, one paragraph finished. The petitioner invokes it's a 32 petition. I know that you are not a better judgment here, so that I would expect. So so the petitioner invokes the jurisdiction. The deputy chief minister is first and foremost a minister. They apply so and so. Instructions likely dismissed, pending application forms. What more?
All the decisions our learned
Now, sir, ball is in your court.
now I am coming to that.
Yes.
So all the decisions are on the basis describing two-tier system. One is a chief minister, another is a minister. So
Council of Ministers.
Council of Ministers. Then it is two-tier. Two-tier.
Correct.
So here in Odisha, if your lordship will look at this, the last amendment, the salary amendment which they have withdrawn because of the uproar in different quarters. So there they said they have created three-tier. Chief minister, salary, and perks, everything is one. Then deputy chief minister, salary and perks is different.
And you say that they have withdrawn now.
They have withdrawn, but that is what, my lord, I have
They realized after this judgment.
my lord, I have
that, the
in my
deputy chief minister is the
specific,
Council of Ministers.
I have taken specific amendment in paragraph 14, my lord.
So you want a revival of that particular notification, which they have withdrawn.
No, not that. Because that is their idea. All these decisions are not matching with Odisha.
Sir,
The Odisha state is what.
Consider you know the series of judgments. If suppose there is a mistake which is committed,
In all those judgments, what
it is rectified. Then why you take such an exception to it?
My lord,
Can't they realize that he is the deputy chief minister is also a council of ministers.
Council of
They have
Ministers.
withdrawn.
But
No difficulty.
in my lord, just paragraph 14, my lord, just have a glance.
Which
Which in my read petition.
yeah, sure.
The petitioner reasonably apprehends
Fine.
because from 13, may submit from 13B. The petition submits that the above principle cuts both ways. If the designation is descriptive and non-substantive, the state cannot, under its cover, create a superior executive tier with the distinct incidence of power, privilege, or expenditure. In December 2025, the state introduced a salary-related amendment bill, including the Odisha Minister's Salary and Allowances Amendment Bill 25. On 26/3/26, as reported, Odisha Legislative Affairs Secretary informed the members that the Parliamentary Affairs Minister intended to seek leave to withdraw 4 amendment bills, including the Odisha Minister's Salary and Allowances Amendment Bill 25. Then, withdrawal of the said bill is a material fact because it shows that any legislative attempt to revise or restructure ministerial salaries or allowances through the said bill did not result in operative statutory sanction. Then 14. The petitioner reasonably apprehends that despite the absence of any constitutional office of Deputy Chief Minister and the reported withdrawal of the aforesaid amendment bill, opposite party number 4 and 5 continue to receive or enjoy special protocol, ceremonial precedence, possible differential staffing, possible office establishment support, special security deployment, and other substantive benefits solely on the basis of improved description. Let them answer. This is not there.
I am answered.
What is their answer?
Milord, I have answered, Milord. Let your lordship hear. I have answered.
My understanding of the
No research. Milord, your lordship, absolutely.
All the judgments are
Entry 40, Milord.
all within their domain.
Milord, I am addressing.
Within their domain, you
Milord,
can't say so.
by this they have created 3 tier.
No,
secret we have.
Sir, there are two fallacy in your stand. I must be very
Milord, that
First
PIN
is,
has been
we
dismissed.
have introduction.
Number one, it has not been
Now the
disclosed.
bill having passed in the floor of the assembly does not partake a
That has been dismissed by your lordship. It has not been disclosed to the present
They
petition.
have withdrawn the bill means it will be treated that it has not been
Absolutely.
legally or statutorily placed on the floor of
No,
the
that is gone, Milord.
You can't
But I
say you are
know-
drawing an inspiration
No,
or reasonable or logical inference
But-
therefrom
but
that this is a mindset which is coming. No.
they are enjoying this, Milord. They are enjoying this.
Let them.
This precedent they are enjoying.
There is
In the
enjoyed by
protocol
first
system, Milord,
95 Act, Milord, I am coming to
even
that.
Chief
Milord,
Minister, suppose as per the
let me
protocol
answer,
system,
Milord, it's very plainly answered. Milord,
It is
entry
also-
40. Milord, your lordship can kindly turn to entry 40 of schedule, sir. Next two.
they
Just-
will segregate the salary system, Milord.
We have
Is
not
it
done
possible?
the research. Let me assist the court.
Probably.
Milord, let me.
They, by that bill, they wanted to do it.
Milord,
Milord,
it is about
is that-
95 the act is there.
That is gone. But
That's gone.
That is gone. But what in practically,
There is a document
Milord,
that they are paid a higher salary.
it
Where is the document? There is no salary system. I think in
no,
No, it is there,
My lord,
Milord. He is not, he has not let me assist your lordship. Milord, he is-
honorarium.
Milord,
honorarium in all field, Milord, they are giving the higher protocol than the ministers.
Has to be.
That is a 3 tier.
I do not know that.
Visibly, that is a 3 tier. All these decisions they are cited,
The other ministers
not covered all these
have
issues.
come forward.
My lord,
Other ministers have not come forward. That I have.
Milord, it is not let me explain, Milord, the position of law.
that is another thing. By that way, this is a kind of
Milord, in
this is a
that
tactical
There is nothing.
this is a tactical exercise. How to create a 3-tier system.
We will
It is in
consider-
shadow, it me.
Yes.
It is in
We will
shadow,
consider
but they have
the
created
conditions of the
this.
judge. We'll consider.
Milord, one aspect your lordship may kindly take note of. Milord, salary, etc.
I am conscious of the descriptive designation.
Yes.
To paragraph 14 million,
just
I will
passing on the
establish
Act of
this
95.
box and whatever, I'll give you in the affidavit. How they are getting what is the difference salary and works and the security protocol, they are being provided, that will submit. That will file in the affidavit.
When you are filing a writ petition, you should
That I can now substantiate that this is my Harish Miller. It is a PIL, not that it is my personal issue. Have they at all answered? And
Under
whichever
competency, if somebody.
they can discriminate.
Virus
That
can be
is the
challenged.
what is
It's the 1952 Act.
Correct.
Miller.
You have any document to support your.
Miller, there is
I'll
no
help to that.
research.
I'll give the
Absolutely, Miller, there is no research. Your
It is-
Lordship, kindly
it
turn
is
and
a-
just
Miller,
bring your Lordship.
what-
Kindly see
what
the
we have
constitutional
gathered,
provision.
even
Where from
a
that power
PIL, even a PIL Miller,
Miller,
even
any
a postcard
court
can
should
give
bring your Lordship at
this
least
is the
kind of
query. The court has to be PIL concept is evolved
Your Lordship
from that
may
concept.
discourage this kind of petition, sir.
PIL concept has to be
Repeatedly, Miller, abuse
Has to
of your
develop-
Lordship process, valuable time, public time.
judgment. All those judgment I have seen and I have relied upon those. I began saying the Devilal case also. I began saying in my writ petition itself. But I am concerned.
Mr. I just wanted to know, if you wanted to rely on this Devilal judgment
Yeah.
or a Devidas judgment?
The Devilal judgment, all the judgment. I
These
take
judgments
exception
you are
to
also-
that.
You are also relying on these lines. of
I have segregated by saying.
judgment.
I have segregated by saying my assertion. I have segregated by saying that they are being given a preferential values by creating them a shadow opportunity and they have created three-tier business, the three-tier position, which is not permissible. Let them say, let them give an answer.
On a pure question of law, we are listening.
Miller, the other petition, Kavita Patra, your Lordship dismissed. I am passing on the judgment. That has not been also disclosed in this petition. The pleadings are here. There is not a single whisper, Miller, that such a petition was. Miller, I am passing on the judgment. Your Lordship. Yes, I was there.
Supposed to know that.
Yes.
That was a different, maybe the prompt
That's
will
correct.
say.
No, Miller,
What
what
is
I am trying to explain, Miller, there, Miller, the first statement is made.
Legislative competency
One
does not give them.
Entry 40 Miller since
Whether this
1952.
kind of
The salaries, etc. allowances are.
That is what I'm saying.
That has been amended in 95.
Reference.
He is not aware, Miller.
Only my
Petitions
I
have been
speak
thrown out
my
at your Lordship.
only on my paragraph 14.
95.
Paragraph
Virus
14.
is not under challenge.
I will answer that.
That is
Miller,
only
your
my
Lordship,
query.
kindly see this act. That's it, 95. Is Miller, there is an act of 1952, Miller, for salary like your judges, salaries, etc. That is since 1952. In 1995, Section 3 was amended. Lordship, kindly see the word deputy chief minister is there.
No.
So for minister, state minister, etc.
It is not.
This act is, and in
Correct.
17, Miller,
These are all-
that was again amended. Your Lordship, kindly see, this is the 17 amendment. So, Lordship, kindly see this 17 amendment. So, this power, Miller, comes from entry 40 of
What
this
you have
law.
to state this, I have seen that.
That Tigers very question. What salary would be decided? It is open for someone to challenge.
That means even in protocol system, in all sense, Miller, they are being given the system.
So according to you, it is not only restricted to the designation, but also
I will-
class.
That is what I am saying. That is what I am saying.
It's a one.
Already memorandum of charge served on
Yes. Shared the.
They have diverted the issue.
No, don't share on.
Already charge has been submitted and letter from June that you must take immediate steps. So steps has to be taken, then charge has to be taken. So they have diverted the issue.
Why you are coming up? What is there?
I have flag marked it.
Because of the negligence.
I have flag marked the relevant page. Madam. That is the memorandum of charge already.
So there is a immediate steps to for suspension. So they didn't go for that. They have taken their so much action. In another way, they are again after conducting an inquiry, the letter has been issued. It is not that letter has been issued by the Chief Election Commissioner. Chief Election Commissioner has conducted an inquiry through ADM and he found the latches at the administrative latches, everything. Thereafter, a letter has been issued to take steps immediately. So no steps has been taken, rather they are going for inquiry or something else.
But departmental proceedings is a government officer. So pursuant to the direction of the Chief Election Commissioner,
After suspension,
departmental proceeding has been.
After suspension?
that immediate steps after the
What is the immediate state? They have already article of charges and all everything.
And that is also served on.
But disciplinary proceeding has
Already
been-
served.
the letter is my
Misconduct.
page 17 I am reading in view of
They will be taken to task if they do not follow.
that,
Conduct
in view of the gravity of the
The
matter,
officer is constantly remaining absent. We have what to do. They have said.
Memo of evidence has also been given.
Yes. And page 20, that is the service.
Yes.
Page 20 is the service.
she is still
It has
working
been
my.
served and it has been.
That has already been done. We are not going to make an inquiry. It should go independently.
That is we are not on that, but the letter is this, my lord, in view of the gravity of the matter and the potential impact on the ongoing SIR, the case warrants immediate attention and for it. That is why
Is it, is a the discharge, dereliction in discharge of their official duty. That's all. What was
the video is the ground.
the delinquent must attend the water training program. If I did not, that's the only concern. That's a misconduct. What is the criminal charge? If somebody does not attend a training program, does it turn them off to a cognizable offense? It's a misconduct in dereliction and discharge of the duties.
That is why the election of.
No, sir. Suspension is there, nothing. But they have already issued a charge. They have initiated a process. It will
Under the CCS rule, it has been done. Under the CCA rules.
That's very.
Yes, that's because he is a government officer, so it has been rule 15 of the OCS CCA.
I have also.
He has to continue on service. Suspension does not terminate the service. Sir, what are you doing? You are asking that he should be terminated because he is or she
Not terminated,
he or she who
or immediate.
she must be terminated. Why?
Not, I am not praying for termination,
You are
ma'am.
praying, sir.
Only implementation.
No.
Only implementation, no termination, what I have never had.
The
Because
officer has not been implemented.
The subject is suspension of ARO and video. I have not paid
Someone
for.
is there and cultivated into an order.
Yes, sir. So that was even that line.
That without going into the nitty-gritty of the release. Claim like that was
Parents of the students, of the upper primary students existing in the village Birivadi, that they have approached before this honorable court against the arbitrary action of the opposite parties in shifting and changing the place for laying a foundation stone for implementation of the Godavari Mishra Adarsha Prathamik Vidyalaya. In contrast,
the said GP.
it is under the same Gram Panchayat, but it is 5 kilometers away from the headquarters.
What can you dictate it that when no, one is whether the availability of the other resources are one of the important factors because it involves the many facilities to be provided. Those cannot be done. Then, how can you challenge it? If it is sanctioned for a Gram Panchayat, it has been done in the Gram Panchayat. We cannot dictate. So it should be place A, not place B.
It was first decided to be
This is a can't the percentage changes. This is any law.
As per the notification of this scheme, on the basis of which it is decided, in Annexure 1, let's see, for a moment, in page number 15, Annexure 1,
Yes.
paragraph number 4,
Yes.
the criteria itself provides that,
Yes.
may I read, schools
Should be preferably situated in the headquarters.
in the headquarters,
Yeah.
ensuring every child of the Gram Panchayat has access
So it
to.
has been done. It is being done.
The headquarters is the Birivadi village, and the village, and in the first notification, it was.
It is said that preferably it should be situated, but there are multiple factors, those are to be taken into consideration. If they have no freedom of administrating, then in that event, everywhere you will come and take a decision.
There are also many other reasons. Let me see the point number 4, my lord, in the page number 616. My lord, it is also provided that school having highest enrollment strength may be considered on priority basis.
Maybe
My lord,
there is a priority that you'll have to first establish it here.
my lord, I have pleaded that in our village, in the petitioner's village, my lord, the strength is 350, and in the village which they are subsequent,
This means
the admission student, my lord.
the students or a person?
Student, my lord. The population is also more than 2,000 in the Birivadi village, my lord. But first, it was decided that the school will be implemented in the Birivadi government upper primary school, and thereafter, without any reason or for the reasons best known to them, they have again in another notification in the Annexure 4, my lord, in Annexure 5, they have decided that the school will be established in the Koyatapalli village, that is 5 kilometers away from the headquarters of the Gram Panchayat. And also there are other reasons that the mining activities also carrying on in the place of the Koyatapalli village, where there is the pollution and safety concern for the students.
Is there any upper primary school within the Biribadi GP? I mean, that place.
That I have to take instruction.
Take instruction of the GP.
Item number 5.
Last occasion, directed for listing of this matter along with WPC number 19194/2026. That is related to the direction.
I do not find this direction.
No, but that is related to
Just matter be listed on 20. It was originally in defect then.
The so motor equitation that's it. This is yes, another matter. That is related.
Oh, this is the cow.
That's
Yes, we have already issued. Then what is the number?
WPC number 193
That is what
2026.
193.
With the statement after 2 weeks.
Well,
Along with that repetition, give that out.
Yes.
item number 6.
Yes. When was the sanction one?
That's it, but before my learned senior begins, may I request my team to take off the case record in item number 14 also for a moment. Item number 14.
What?
See?
Give me the 14.
The same petitioner, the same cause of injury.
Upon putting the bill. It is capable for you. Fix,
I am appearing.
You are a different lawyer.
I am appearing. But before that, I have taken notice under Rule 8 of the Odisha High Court rules. He has authorized me, and I filed the first notice, then filed the writ petition because they didn't take action. But I heard today that government has taken up action on basis of my Rule 8 application.
I understood, sir. I'm not considering now. There are two writ petitions by the same person.
Yes, yes.
One is you are filing
Yes.
the writ petition, another he is filing the writ petition for the cert cause.
But I have taken notice on 20th July.
Abuse, whatever. Is it not an abuse of the process?
That
You may have filed earlier.
Yes.
I don't say anything. Is it not an abuse of the process?
Let me see the affirmation in the first case, actually. The affirmation at first case at
24 July.
and in the second case thereafter. And he has stated that he has not
So
filed any.
you are presenting the second one.
No, yes. But I have taken notice under Rule 8, Annex 8, that is on 20th 7.
What is this rule 8?
Now, the Odisha High Court rules, if
What
before
it
filing of
says?
that, we'll take notice.
No, you are not understanding what I am thinking about.
Because that has.
It appears that for the sales and relief,
Yes, person.
the same person has filed two petitions.
Yes.
Now, you have to consider whether these petitions, whether he will be permitted to do it, changing the council. You got it a first letter. His matter is earlier.
But I found because I have taken notice under Rule 8 of the Odisha High Court rules, where it says that before filing that we'll have to take a notice. So I have given that notice. It's on 20th July. No, in that case, I think there is no notice. There is notice. Advocate notice there.
And not advocate.
I have said that my.
It's not necessary that.
Yes, sir.
Litigant can give a notice. You have to make a representation.
Yes, sir. That is representation. That is my representation.
They have also said
Obviously.
the same
There.
person.
Yes, sir.
He is HON'BLE and he is trying to encash
Yes.
the process of law. Will it permit? Will it be permissible? Will it dismiss both? For such recalcitrant litigant should go. Wanted to take advantage.
Because in my case, there are two writ petitions. Along with that petitioner, another person also has filed. Two writ petitions.
I'm talking about this.
This person. Yes, sir. Siva Prasad, sir. Yes, sir.
I'm talking about.
That's it.
Both of them has. And I could see the signature is practically the same of the way.
Yes.
So.
And representation in the earlier case is also
The same.
Yes, sir. No, I'm not saying representation, Lord. The objection, but after filing of objection, they did take action. So he approached me that I have taken notice. That is not I am.
Annexure 6 in the first case and
Yes.
Annexure 7 in the second case.
Annexure 6 is the public objection. Large number of public has filed.
So, representation objection filed by the local councillor and resident is on 28/6/2026 and 27. And then again, formal objection under 6/6/7. And here you have said Public domain, just imagine what he's doing.
My objection has been sent to registered post on 9/7/2026.
True.
Let's see.
That is what I'm saying. And
I have
he's
given the
already
also
filed an
postal
objection
receipt also. I have
of
given.
6/7 as well.
Because it-
Matter.
Because it was given to the collector, Balangir, on 9/7/2026.
So, will not, public interest litigation cannot be misused in this fashion. We are imposing a hefty cost of this. And we are imposing a hefty cost. Sorry, he is more interested.
Item 4 may be permitted with the
No,
six. So, you can call you something.
he's also not sure. First, he says that this Titilagarh offshore is situated in ward number 8. Here he says
Ward
that it's
number
situated in ward number 9.
That is under challenge. He has opened the shop beyond the sanction locality.
Sir, your case,
Yes.
looking at your case,
Lots
you
of-
says that you have also opened a shop in ward number 9,
Yes.
but at a different place. Instead of railway station road.
Yes.
he
No,
has
that is the
started
sanction.
Belgaum Road.
Railway station road is the sanction locality.
Please, Belgaum Road,
Yes, Lords.
which is also under ward number 9.
Yes.
In his writ petition,
Yes.
we have the same prayer is that objection not considering as per the law within the same consequently a direction to shift Titilagarh offshore from the residential area of ward number 8.
Yes. But it's not in ward number 8. It is ward number 9.
Then he is not sure
Yes.
where it is situated, ward number 8 or 9.
But Lords, you will find in the objection, they have stated that we are the residents of ward number 8 and 9. Yes, Lords. That I have also got the English translation of that Odia annexure.
No, sir. We'll have to discuss with cause.
But my lord, here I have challenged also the grant of license. The objection is there because license is granted somewhere, some other place, but he has opened in another place, in the residential area where the public notice has not been issued. Because public notice has been issued to the railway station road. I have given the annexes, all annexes, my lord, I have given. My lord, you will find from the public notice annexure 1 I have given.
Let them, whether you are correct or his statement
Yes.
is correct. Because your client's role.
I'll show Lordship, I'll show the Lordship of the license. License and their public notice and sale notice. Public notice and sale notice, railway station road. License is not there. That is absent.
Where is the notification? Of 26 number of.
Let's say
The annexure.
page 21 of the first case. At page 21.
So in your case,
In the interception.
But in my case, it's page 35. Serial number 14.
Let's see page 24 of the instruction manual. With that geographic formula, is here on that. Last page.
24 is the,
And point A is the soft miller, point B is the railway station.
page.
Let's the last page.
Page 34.
But in my case, page 35.
35.
Let's see, serial number 14. Name of the pillar exercise Titlagarh and locality is ward number 9 of Titlagarh municipality, railway station road. That is the locality, specific locality. And in the license, that is not there. Railway station road is not there in the license. Annexure 6, page 39. The locality address is given ward number 9 of Titlagarh municipality. The railway station road is omitted, so that's why my lord, he has opened in Belgaum, another locality, for which lordship public notice has not been issued, as required under Rule 30 to 31 and corresponding section is 30 to 47, 42. So that's why my lord, the public has filed residential, he has opened in residential area. So public has filed, that's why. Why you have filed in? Because it was there in the earlier.
Why you are identifying a particular road on which it has to be open?
Lord, up to 30th July, the shop was opened on Station Road. Thereafter, this is new license. He has opened in another area.
In that road, miller, railway station road.
No. The structure is not there.
If you lordship can see the last photograph.
Yes, you have said he has opened it on a road which connects to the railway.
Yes, miller.
Connects.
Yes.
Another thing.
That is the two thing. There are many roads which connects
Yes, miller.
through many other roads.
But the ward number is same, miller. Ward number like.
But why you have when you are saying that you should say only the ward number?
Lordship, I have given
Why
public
you are
notice.
Identifying a road.
Public notice inviting objection for
Why you are
26, 20.
inviting a road?
Miller, in the public notice, miller, the road was written as railway station road, miller.
Yes.
And
So,
Why you have given a road? Then it should be on a railway station road.
that,
yes, miller. Actually, this
Any road which connects, no, that's another road.
actually there is no other road to the railway station, miller. That same road.
Then it should be a railway station road, a long stretch.
Yes, miller. That is the only road, miller.
Then only road.
Page 24, miller. That is the only road. And the thing is, miller, they didn't raise within that stipulated time period. Miller.
He says that I may not have raised an objection for railway station road. But once you have not invited a public objection
Yes, we are.
on this road, this is a BP road or something.
Belgaum.
Then how they will file an objection?
It is not Belgaum road, miller.
Yes.
We'll file affidavit for that.
You are saying, sir, your instruction is saying that it is the Belgaum road.
That is also goes to the Belgaum, miller, and also to the railway station.
What are you talking about?
Paragraph nine.
Your contention is that it is within the ward number 9.
Yes.
No difficulty. There is no dispute that it is not within ward number 9. But if it is on a road, then a particular road has to be then open. Very interesting. You have said importance, that importance is against you.
Then that goes to the railway station.
You know, you say that it is not that road. Then in that event, how can you issue notice on that? Have you included them?
Yes, but I've included part. Okay, number 5.
What do you say? It's permitted to.
Okay, number 5.
14. 6. Item number 7.
Okay.
When my last, the present petitioner has become a victim of fraud, my. In fact,
Fraud.
yes, sir, because it is alleged that the present petitioner being it is alleged that present petitioner being a beneficiary, is being a beneficiary of a central government scheme, which a farm pond was been digging and matter has been executed in his name, bill has been raised and bill has been disbursed. So only after an audit, it has come to a newspaper, thereafter petitioner came to know that the money has been withdrawn in his name and he has not been. Yes, in fact, that is my case.
So
He is the victim of
FIR has
fraud.
been lost.
Yes, madam.
FIR has been lost.
No, I don't, because it's a case of 2023-24. I have no knowledge behind my back, bills have
Whenever
been,
it came to your notice.
bills have been raised. When a departmental inquiry in 2026,
Clear case of a fraud. If it's a clear case of a fraud, why must you go and lodge a?
that is why I need an inquiry by the collector and take action against the government official 2, 3, 4, my lord, because they are the men behind this scheme, my lord.
Is there such cases in other areas also? Or it is
Yes,
confined to this
same as
bill?
another pair also have pending that
If that man has done this in other areas also, or it is confined to this case only?
This panchayat.
Yes,
this panchayat, this panchayat.
Individual
This
case.
panchayat, the executive officer who is responsible for this, they are making allegation against him. And the recommendation is now pending before the collector in May 2026, they have made the recommendation. So what is the real fact? I have to inquire and.
It's a very serious issue.
Yes, it's a very serious matter.
Maybe
Serious
you are
matter.
not going
If that
to
is so,
the
then all these three officers have to.
If that money is withdrawn in his name, then
You did nothing.
he says, I have not done it, I am not a beneficiary.
Only
All was deposited in the account.
They have already disbursed the bill.
So unless these three officers
But the
have.
money has gone in your account.
No, man. I have no knowledge. Only after a conduct,
Only.
Money which goes, it goes into the account.
they have given to somebody else. I don't have. Only inquiry can reveal everything. I have not. Nothing has come to me.
No, how
Only.
could you know that?
Yeah, exactly, my lord. After a social audit conducted in the department, then it has come to the knowledge. Thereafter, in the publication in the newspaper, I came to know. Then I gave a repetition to collector to conduct an inquiry.
Take over any other day, I will take instruction after what has happened in the matter. If the matter is finished.
Religious allocation. It against the
2 weeks means he will give you a date.
Yes.
Tenth.
Is the present plan has been filed on behalf of 15 affected children. On behalf of 15 children who are suffering from muscular dystrophy, madam. It is a rare genetic disease, madam. That is,
As usual,
Yes, but that is circular with regard to that 10 lakh rupees is to be given by from the
I'll
state.
enclose that at Annexure 6.
Annexure 6, that is there. But unless you get the fund from the central government to meet the entire expenses not possible by the state. The central government is more than crores of rupees. Central government is providing the scheme.
What can kindly have that, sir?
what are you doing? You are for the central government?
Yes, sir.
What are you doing? These children cannot suffer because of you.
The specific notification of the government of this, as my one senior point out, you must make policy annexure 6 and page 146. 146.
Yes.
Annexure 6.
146 is the.
148, 148.
In my.
148.
That's
148.
That is the
148.
notification dated 6/5/2023.
148, yes.
Real option policy. Consider the hardship for the treatment of the patient suffering from.
Out of the CMRF,
That the financial assistance of 10 lakhs is provided to the one-time financial assistance by the state government. This is the notification of the state government. And in serial number 4, the disbursement of 10 lakh only
Sir, it is, now the state is shirking the responsibility of the central. The central is shirking the responsibility of the state. Now what we do, the fight between the two giants, why the small.
it is only the notification of the state government.
What is this? That's why I'm saying both of you are really rolling the ball in the respective courts, but ultimately the beneficial piece of the scheme is being frustrated, and I would say the beneficiaries are still deprived. What to do? It's a genuine case, they are entitled. Will you not give them?
I will take instruction with
What instruction? Every time I have seen these are the
Well,
very
I-
routines,
I told
the practice that moment the matter comes for the first day, it is always that to take an instruction and show. You were served with the copy well ahead. Is it not your duty to immediately approach the concerned officer?
We are already almost yet to be received the instruction. That short date also.
I know,
Why it's so delayed?
but there is a reluctancy on the part of the state or a central council. When you were served with a copy of the petition, when the service was effective,
14/8. 14 of this month.
then and we are off. 27, 13 days have passed.
That already
Will you not take an instruction immediately?
Item 9.
Lordship, I am a petitioner. My number there is to challenge the high-handed illegal arbitration action of the opposite parties. The opposite parties represented by State of Orissa, Collector and District Magistrate Jashpur and Tahsildars. It is not removing illegal authorizing of public road. Plot number 1464 and 1496 and 1739 under Khatian number 788 of Moja Chandripur Jashpur Tahsil. Kindly Lordship, see the page number, annexure 1, page number 10. Also roads 1467, 1696 and 1739.
You can't read.
Why are you not supplying a translated copy? You have taken undertaking, you have put an undertaking, no? To place it in English.
The missionary is not well, so he is not unable to attend this course.
But madam, while you have taken up the responsibility of moving the matter, if you not take also the responsibility? Because if you want to rely, I can't lay hand to it. I do not know this. What is written, I can't say.
Fix it.
Prayer is made to remove the enforcement.
Item 10.
May I please, Lordship? Your Lordship, the file is petition seeking a direction from the opposite party number 3 to take appropriate action for providing water to the villagers and other animals from the water body, that is Moirajora number 3 under Doddepamanpur Gram Panchayat. My lord, these conditions under Annex 4, the translated copies have specifically point number 12, my lord. Point number 12 says that the person who is taking the lease shall not cause any obstruction to the villagers and the animals from using the water in the water body. Our specific grievance is that despite us having submitted several representations before the opposite parties regarding the non-supplying of the water, regarding the obstruction caused by OP number 5 in the water body, still we are not being provided with any water from that water body.
No, genuine public grievance involved, they have represented to the block development to copy to the collector. I will take the issue with the collector, let it go on again. Because the water is not being used by the villagers for the purpose of bathing of the cattle and for the purpose of drinking also for the cattle. That is genuine grievance. And that's what that has been given and lead to a government official, central government official.
So now, after the enactment of by the central government, I think there is already act that has come that you can't, I say, completely fill up the water bodies or you can't do it because it brings an ecological.
Normally, one important grievance involved which the cattle must be allowed to take the water from their deep for the purpose of their drinking and all that.
The water body, how can one fill up the water body? The natural water body.
It's not about filling up. The opposite 5 number has OP number 5 has received the lease for farming the fish.
Oh, physical.
The pisciculture.
Pisciculture.
So,
but we are saying that is the lease condition under which he is granted lease that stipulates that he shall not cause any obstruction to the villagers or the animals from using the water from that pond. We are not asking to fill it up, my lord.
what are we doing?
Let me talk to the collector and let it come on with you. I will see that grievance.
Next week.
Item 11.
Grievance of report. You could see this policy page 53. For the first time, the state has made a provision for demand 10% excess for having an additional bar. Kindly see page 53. Plus 4.3. Annual license fee.
What is the meaning of this?
Yes, there is only kind of licenses FL4 form and FL5. This additional bar provision is not there in the statute, neither in the act nor in the rules. What
is the concept of additional bar?
Additional bar means in addition to the existing bar in the hotel. But existing provision, if you are having some other counter also to serve it, then they will charge 10%.
I also perceived. I just after the clarification.
They will charge 10% over and above the license fee. But in my case, I do not have the additional bar, nor I have taken a license to that. Still, then they have collected for. That's the whole point. But I have paid you with protest. I seek refund of that.
To take instruction, man.
But apparent on the face of it, I have not been issued with license.
Let it come next week. Take next person next page.
You are a second, highest official in command, as far as the state is concerned.
Today, for the first time,
When the copy is served, why don't you immediately approach the officer and then take the instructions?
really it has not come to mind for the first time which has come. Otherwise,
Sir, it is your office, sir. You are a second in command, sir.
letter has not gone
As a
to the.
government,
Sorry, why not?
advocate, we call it a government leader. You are like a government leader, second in command after AG.
No. When copy is short and also, I am asking the section officer also to intimate the officer.
I have been really trying to crack the nut. I am unable to do it till now since last many months. Every time any matter was listing, let me take instruction. Second listing, I have not received instruction. Unnecessarily, you are exploring the topic.
Yesterday night I received the wondered what I can do. Probably next week. Probably next week.
Until date, I have been pressing hard, saying that once the brief is allotted to one government advocate, he should take responsibility till the end. I find every day the new allotment comes.
Remember,
There is no noting here also, the earlier it came for admission.
The system in which you work, what can be done?
Let it come next week.
Item 12.
Item 12 is regarding fire safety. But it is below the 12 meters height and.
Yes, there is already a.
Judgment is there.
Yes,
There's
sir.
already a judgment by us.
Yes.
It's not enough.
Yes.
It's the number.
Not I give you. Already I have filed.
Yes.
Item number 13.
Second, Lord, here, Lord, I have challenged the order of the collector on the annexure 5. Lord, he is directing to fix the sum. Lord, although the government has sanctioned that sum, Lord. Under annexure 1, Lord, you can have glance, page, Lord, 10. The plot number has been given. This is, Lord, also by shifting, the government has approved. Under annexure 1, page 10. In pursuance of order of government excise department, by so and so, Collector Keonjhar has been pleased to allow.
This is the plot number.
Lordship. Lord, I am operating there now. But now collector is saying that you shift the sum. This is not as per the government order. And government also now prohibited that up to 30th October there should not be any shifting.
Yes,
Lord, annexure 5, the impugned order. Page 27. And collector has no power also. Under rule 53.5, commission is the power. In case of shifting, the commissioner can
No, it is the superintendent of exercise.
communicate
Communicated
by order of collector. Yes. There also, Lord, I have given another order of this own court where this own court held that collector and superintendent has no power.
No, if it operates any of the judgment of the Supreme Court, that is that case.
Yes.
National Highway.
Yes.
Then
No, the national highway is not there. It is in village. They have handed over that road to the national highway authority. That's why I made also national highway authority as a party. It has not been started. Nothing has been started. And no notification. Under the Land Acquisition Act, no notification, nothing. As village road is there.
The distance form has been reduced.
Village road, there is no restriction. In the village,
The national highway passes through a
we are 220. 220.
You are coming within 220.
Yes, sir. But it is not national highway, bro.
No,
That's
that's
it.
it is already
Declared as national.
Not handed over. That they have said, that has been handed over to the national highway authority. The road has been handed for national highway, no. But it has not been done. It is not, still it is
But they will not initiate.
not started. Will have
They will
specific
not initiate
stated.
any preliminary work to ensure that the road is
No,
clear.
it will take another 4 years or 5 years.
No,
Preemptive measure, that why after the national highway is actually constructed, then
No, that's it. Not earlier also the license.
preemptive measure,
Yes.
because
This is now present license.
many workers will be working there in the national.
No work. I have stated no work has been started.
Many workers will be there,
Yes, Lord.
your
But-
shop.
No, it should be a national highway.
You know, in that case, whoever has
Not,
been-
it is not, process has been started, nothing has been
whoever
done.
has been now evicted from that place and.
Because the earlier licensee had approved, and this one court also granted stay. Even then also the collector has granted this.
What?
But the earlier licensee, because I am new license. I got license on 1/7.
Another
licensee
got this stay.
Yes, sir. That is also pending. Stay order is there.
No, he has no subsisting right because he.
No, I am not new license.
So what?
Because they are saying that it will not be applied to you. That order will not apply to you. He has already approved. Because that is other
What do you
licensing.
say, madam?
As per order of 4th August mileage, it says that the shop comes along the proposed highway mileage. If the steps would be taken, right now will commence once the notification comes, but once the shops are removed, only then the constructions and other work can commence in that area. That's why this notification.
National Highway Authority have already issued the notification or something
No.
that this national highway will pass through this.
That I'm not aware of, that National Highway Authority might be able to answer my this, but such notification I'm not aware. But in the order it says that it comes along that.
Right, not absolutely.
National Highway.
I'm very party as copy number 5.
Please give a notice that they are supposed to buy
That's
that what they want.
Item 15.
Status quo because not there harassing every day.
Dangerous.
Because there is already and the collector has no power. Lordship can have glance 53.5. Rule 53.5.
When the final order would come from further, we consider.
15.
There are two judgments of my Lord's Lord, Sandeep Raiguru and also one Anand. Two judgments, your Lordship, in clear words have been pleased to hold that Superintendent of Excise has no power to direct shifting of the shop. But here the Superintendent of Excise has directed to shift the shop. Kindly see your Lordship judgment. Sandeep Raiguru and Guru.
But I have given that judgment also.
Clear judgments of your Lordship.
I have given another.
And my shop is closed, but it's a sanctioned location. Formal notice was issued. No objection was there. They granted me the license. I operated the license for 15 days. Suddenly, thereafter, public raised objection. But earlier also the shop was operating over this area. Earlier license was there.
What about 33-2?
33-2.
Yes, while its objection were received after the form make notice was
Can
issued.
you
No,
act
no.
upon that?
But my lord, since
Can
it
you
has
amend
to
the
be-
rules if you have retained it and in unequivocal term or clear term says any objection received after the statutory period shall be summarily rejected.
Yes.
Then how can you proceed on the basis there?
No, my lords, when the people protested, my lords, after opening of the shop,
So you
law and
can
order.
defy the provision of law.
No, my lords, just to control that situation
So
temporarily
you
from
suspend.
escalating further, that's why my lords is a
You
temporary.
suspended.
No, my
Shop
lords,
is
no,
closed.
so the key is with the petitioner, my lords. The discretion lies with the petitioner. If
What?
he can open the shop and function it even in the presence of protests happening around it, then he can do so. He has also
So,
submitted.
we are recording your submission.
My lords, he has also submitted.
We are recording your submission.
My lords, petitioner.
And we will say that yes, we say everything.
If minus the petitioner has also submitted a prayer petition before the collector minus for shifting of the shop from one location to another minus. So once he applies for it and then after due procedure minus.
No, we have not applied for. Kindly see page 54. I have given the photograph. Excise authorities themselves are sealing my shop.
How can you seal the shop?
They have sealed it.
There's no seal order. as
Photograph
such.
can see
Have
page
you
53.
not
Just see
seen
page
it? Have you
54.
not seen it?
Kindly see.
Yes, fine. That
Have
was
you not
only
seen
just.
it? The
Oh.
page,
The excise authority in uniform, they are sealing it.
Yes,
Page
but that
53.
was
54, I'm sorry.
53.
Situation.
Can you-
These people
I'm
were
asking you,
protesting
can
in
you-
that area. So
can you,
this is a temporary measure which it was done. my lord.
can
After
you,
that.
you are authority to act within the codes of law. Tell me where is the power of sealing? And under what circumstances you can seal the shop?
Temporary closure, section 26.
26.
They have not done it. They have not followed. Then two, they have sealed it. Themselves, they have sealed it.
Melissa, if I may share the prayer petition matters, which he has prayed for the shifting of the shop from one location to another.
But this is some other shop, not this shop.
Since when it is sealed?
Well, they have sealed it. I have given the date. They sealed it without on the 18th of July 26.
More than a month.
Beg pardon.
More than a month now.
Now, no, let me tell you. They sealed it. Thereafter, when I raised the objection, then why? How could you seal it? They removed the seal with a direction to me that don't open it. That's how it is now closed. No, there can't be a privileged communication. If you are giving to the honorable court, you have to show it to us.
Shop number 6. It's towards the end, if your lordships may kindly see. Kindly grant, facilitate permission for shifting of shop to the nearest wall.
This is your prayer. He has not applied.
No, this is Malik's Rinki Gupta's signature is there, Malik.
No, this is what a letter. It's your letter. It's not a privilege between the departments.
No, he gets instruction, Rinki Gupta.
Second prayer.
The signature is here. Send it to the client. Let it come next week. He take instruction. Misleading.
Oh, first, yes.
Item number